esteemed judge say in a trial practice course that between facts and law, facts are 100 times, or at least vastly, more important than law. And in these blogs, I often deal with law, but I use that hopefully as a framework for case development. And by case development, I mean finding facts that fit into the law. And I don't mean to ignore the importance of facts. So I'll talk to you today about how we go about proving some of the elements of a case. What is the best source or evidence that will help us to prove my client's case? Well, the first is a term known as percipient witnesses. That is, people who actually perceive an event. If it's a car crash, a fall, a construction site accident, who was there? What did they see? What can they tell us about what happened then? What can they tell us about a mode of operation or that has gone on historically, even though some of that may not be able to be used if the case is tried? We can do all kinds of research nowadays, of course, on the internet. And that will help us learn about standards in a construction industry, for example, or standards in a retail store for various kinds of things. Those are that research that is done will hopefully reveal some very important facts and questions to ask in depositions or in other forms of discovery of the party that is being sued, that I am suing on behalf of my client. Another source are business records. If it is an entity, a corporation that is being sued, or something like a corporation, what kinds of records do they have that bear on the event? What kind of investigation was done? And what kind of procedures are their employees expected to follow? All of that will come into play and provide, at minimum, good background. And those are written documents, but of course, employees from an entity being sued or even another entity not being sued, we can learn quite a bit in the course of discovery, specifically depositions or from written documentation. And there is also the notion with businesses of routine business practice. And I had that in the boiler case that is on my homepage, and there is a separate part of the website dedicated to what I may say was a very, very nice success. And I would like to give you a little background on an aspect of that, a very small aspect, but important. After taking the depositions of the defendant's employees, I asked my client, they said they had prepared this boiler and that you were impatient, got frustrated, and tried to breach this pressure vessel, and when you breached it, you got hurt. He said, no, absolutely not. I wasn't warned in the way that they say I was. I wasn't warned in any way. So I said, well, it occurs to me, did you ever walk off a job when a vessel was under pressure? And he said, yes, I did many times. Well, in response to that, I got an idea, and I sent him and a lawyer who worked for me to go through boxes and boxes of records at his employer's, who was not being sued, at the employer's office, to find out examples of just when and just why this employee walked off a job. Sure enough, we found over 30 such instances dating back to, I believe it was 1987, up to the time of his accident in 2007. So 30 times there were job cards which indicated that the machinery was unsafe for him to work on. Now, we had what was known as a motion in limine, and I wanted to introduce at the trial those records. And there were reasons why the judge felt that that was not the business practice. However, the judge made a very important concession. While he wouldn't let me introduce the 30 or so job cards, he, the judge, did let me ask of my client, if this boiler were under pressure, would you proceed forward with your job? And he would be permitted to answer, as the client did at trial, no, I would never open up a pressure vessel under pressure, and in fact, I did leave many a job. I like to think that the fact that I did my research and was able to produce 30 job cards permitted me to get in evidence that much. And that, I have to say, may well have contributed to a very, very satisfying result. Thank you.